All right, written form. All right, oral form of agreement is also acceptable. Only in the case of Eastern Greenland case. Written form, all right, okay, today is a must. Right. Long ago, oral form agreement in the case of Eastern Greenland, okay, itu apa nama treaty dia? Interhandle Treaty. Interhandle Treaty. Alright, I'll come to that in a minute. Right, but the moment in 1969, when Vienna Convention has been, right, Vienna Convention has been codified, and then it becomes a convention that leads to the law of treaty, all right, okay, from 1969 onwards, all treaty must be in a written form. But Eastern Greenland is an ancient position, all right, before Vienna Convention was established in 1969. So before that, written treaty can, oral treaty can be accepted. The facts of the Eastern Greenland case is like this, all right. This country, all right, found there is a tundra area of Eastern Greenland, all right, okay, right, in a Greenland, it's divided into, in the beginning, the power is only given to, all right, sorry, the sovereignty of the Greenland was actually in the hands of Norway, Norwegian government, but the king have made an oral agreement, all right, okay, to extend Eastern Greenland through the treaty. The treaty did mention it, but the oral agreement between the king and England, all right, with regards to Greenland, have already been exercised. And for a long period of time, everybody knows in the part of Eastern Greenland, that part doesn't belong to Norway anymore. Later on, when the new king come into the throne, all right, he wanted to acquire the whole Greenland, all right. So UK went and protest that part of the agreement in the Interhandle Treaty does mention the oral, all right, does mention that the king have given it a gift, right, to this state to manage Eastern Greenland. So therefore, that one is considered as promises, although it is done in oral form. Okay, so therefore, there is a free consent because part of the treaty is in the Treaty of Interhandle. The other one is, all right, there is a good faith because for a long period of time, all right, they have used and managed and understood that that part is no more belong to the Norwegian. So you can now retrospective go back into the promise. Treaty is like a promise. It's an international, right? It has an international character. So nowadays, all right, oral form of agreement, it's no more accepted. The form, but it's still a good law. Only they will expect it to be done in the written form because section 2A has said so in the definition of treaty. Okay, right. Now, the third element in the first, all right, section 2 is governed by international law. It must be governed by international law. Right, so what is international law? Again, section 38, clause 1 ICJ statute define to you what is international law. Treaty can be done through a treaty. A treaty can be done through a convention. Treaty can be done through customary practice, all right? Okay, treaty can be through done through the principles of a civilized nation, or treaty is done legally by the court. All right? For example, treaty governed by international law. The treaty that allows British to rent Hong Kong for 99 years. That is a good treaty. In that treaty, it submit every rights. China submitted every rights. Even when, if you were born in Hong Kong at that particular time or within the 99 years of the, of the contract, you will not be citizen of China. You will be citizen of UK. All right. Same thing goes to Macau. It is rented too. All right. Okay. Uh, um, the concession were rented to 99 years to Portuguese. So Macau will always be a Portuguese. Everybody born in Macau, still the 99 years have not expired in the situation of Macau. Soon it will be. Then Macau will be handed back to China. All right. Okay. So you see, governed by international law. Okay. Right? Okay. The most dangerous when it say governed by international law is that the second section of 38 clause 1b. Section 38 clause 1b, customary international law. All right. Some king gives some land, all right, as a gift. All right. Okay. You don't have to have a writing. You only have a king to award you with the land. In England, that happens quite a lot. That's why today there are a lot of lords in England that own a vast area of land. All right. It become what? It becomes law. It's a treaty that when the king conferred. All right. In France, there are a few parts of France that is the king of France, all right, gave it as a gift to some people of the British citizen. So they honor that is a treaty, governed by international law. All right. Okay. The content of the law that affects it must be international. All right. In the scope of international law, section 38 clause 1a gives you what are the international law. All right. Okay. Next one. Embodied in single or two instruments or more. What does it mean? All right. Your agreement that you sign can be one first content, and then after a few years you want to have some additional, all right, and then you add, after a few years you want another appendix to describe, to solve the problem. Maybe there's a conflict, maybe there is no conflict, but you want to add protection, right? Then you have an appendix. The single instrument, meaning there's only one instrument. In a situation of our federal constitution, which is a treaty between Malaysia and the state between Malaysia and all the states in the Malaysia, all right, territory. Okay, we have only one single instrument, but it get amended, all right, it get changed, tapi bukan it get an addition. All right, I'll show you an example in the Treaty of Antarctica. To protect Antarctica, all right, scientists have this treaty. Antarctica is not a state, but a treaty is between Antarctica governors and the rest of the world. All right, okay, you can become a member to protect Antarctica. You sign Antarctica Treaty 1959. Right, what are we concerned about Antarctica is, all right, it plays a role, very important role in the environment. In 1991, the whole world understood the importance of Antarctica when they discover the layer of ozone that is cracking. All right, so Antarctica is being understood to have played a role. There are no humans who live there permanently on Antarctica continent, but the ozone layer were cracking, right? Crack because of the activities of heat from the rest of the world. So what is the function of Antarctica? Is to balance up the coolness, sejuk of Antarctica, to balance up the heat of all the human activities from all the continent other than Antarctica. The heat will pass around Antarctica. Antarctica will cool it down because the heat was too much. There was World War I, World War II that leads to the crack in ozone. So that ozone can be repaired if you preserve the coolness of Antarctica. So That makes Antarctica a champion in environment. Therefore, they produce the second document. The second document is called Protocol to Antarctica Environmental Protection. That protocol in 1991, all right, okay, it's so specific what the world must do, especially the country that is a member to Antarctica Treaty, which is Malaysia, also one of them. At that particular time, in the year 1991, there are 39 states as members, Malaysia, and then there are 2 more at the same time coming in as member. That makes Malaysia one of them at that particular time in 1990. Malaysia did not sign it because Antarctica Treaty has already been enforced in 1979. Malaysia only signed it, but Malaysia is a member, observation member invited by. All right, okay, so we become a real full-fledged member after we give ascension, all right, persetujuan to be and be responsible in 1991. But the point I'm making here is that Antarctica is a treaty. In the beginning, it was a single document, but after they understood, all right, many other things related to its present, they then make a second document. That is the second instrument called the protocol. And later, they even have the third instrument, which is called the appendix. Over in the appendix, each part of that is related to preserving what? Preserving the coolness of Antarctica is done in 6 different appendix. All right. Okay. Now 6 different appendix. If a country is a member to Antarctica today, there are 52 country member to Antarctica Treaty. 52 out of 199 states. 52 over 200 states. Depend on how you want to count how many states in the world. All right. After 197, United Nations start producing the number. All right. After the last state of Timor-Leste, that makes it 199 states. United Nations stop talking about new member state that is being created. All right. Okay. One of these days, United Nations will display how many new states after the last Timor that becomes a member. That will be a different story. You don't have to worry about how many number. But I wanted to say, even though there are only 52 states in Antarctica, but their rulings in the treaty, how to govern environment, is being, all right, okay, enforced throughout the world. But because the world were not paying attention to Antarctica that much, that's why United Nations have climate environment, 2015, Paris Declaration, Paris Agreement. And that's the reason why there is Global Warming Convention. There are Global Environment Convention. There are Stockholm Declaration, all right, okay, and there are many more. United Nations then take charge of environment after the treaty and the supplementary treaty of Antarctica able to prove the role of Antarctica. All right, okay, so the point made in this is that a treaty can be started with just a single document. Through times, the treaty can grow into second agreement, a third protocol, a fourth appendix, for example. It doesn't have to bear that name. All right, okay. UNCLOS 1982. That's the famous, the best, the most respected of treaty in the world. That 197 countries become members to it before it comes to be enforced. All right. Okay, that one also has a supplementary agreement at the back. All right, the first one is just the single text, and then they have the supplementary agreement, and then they have the second supplementary agreement. It's not wrong to have it later. All right, and some country demands that. All right, some country demands that, and United Nations nowadays did it. What? okay, that if you have a single document, very important, then you want to have a new document, this new document must also be signed and ratified. All right. So it's not wrong that our Federation of Malaysia to have second, third, instead of amendment, all right, to have another protocols. Maybe in the future, all right, you want to think about it, right? But then again, this protocol, this second instrument, this additional agreement or appendix can only be done if the main text says there can be supplementary additional agreement after. Right? Okay, if the body of the single text prohibited any other, then you can't add that new addition to the treaty into this one very disciplined treaty. All right, you can't add because the content doesn't allow it to be so, right? But you can sign another treaty, isn't it? Right? Okay, it's time to sit down, maybe to have bukan a second federal constitution, bukan. There's only one. If you have a second one, then the first one is not supreme. That will affect a lot of rights and a lot of law and a lot of decision. All right. Okay. So what you want is another agreement between states in Malaysia. I'm not giving you ideas, but I'm telling you in a treaty, if that you have to study the Federal Constitution of Malaysia or the treaty that is put in front of you. The content of the treaty must suggest that it allows, all right, another instruments to come in after the treaty is signed. Sometimes they put a content like this: second agreement, third agreement, or any other establishment after the treaty is signed. All right, all parties must agree to do the next one, to do the next additional, to do the next instrument. All parties must agree. Dengar tu the word? Or we use the usual word in the constitution. A 2/3 majority party agrees. That's dependent. So you see how binding a treaty is. If an original one doesn't give it some opportunity for advancement, then it cannot. But that doesn't mean, right, you cannot have a different treaty to cover all the situation. But you can't have an extension of the document to cover the loophole or the desire that is changing in the world or in the state. Okay, right? Embodied, these are the names I put there. You can call it agreement, protocol, charter, exchange of notes, or annex. Right? There is an intention to create legal relation. That is really very important. All right. Why do you sign? Because you want to create a legal relationship. That is also being argued in the case of Kelantan. Why do you sign? In the case of Petronas, in the case of Terengganu, in the case of Sarawak. Right? Okay, you sign because you want to create legal relation between the two. If you have achieved it and now at the end you're not satisfied with the percentage that you received, that would be a negotiable situation, but not to have the treaty terminated. Right? Okay? Kat situ kena ingat. A treaty, if you're not satisfied, sign another agreement about the percentage. And that is how, all right, Malaysia have already, okay, done in a situation of concession in Terengganu, in a concession with Sarawak, in the dispute in Malacca. All right? Okay, Malacca is not reported. So therefore, you have seen the element to create what? To create a treaty. In the simple definition of treaty, you have to have, all right, 5 explanations over there. So in my exercise test that I've given you, all right, you are to evaluate the treaty. You see that questions, I have already cut it from the previous, all right. I edited from the other, and then since it was in the PDF, I don't have the words, I can't put anything else, but that is a test. You read it, you evaluate. The question is in A, you are to decide whether there is a treaty or not. Read the facts and then find this element and the rest. All right, okay. It's one of the most difficult questions of international law. Right, you see, so you can't go around and say that you refuse to attend. That is part of your test number 1 that gives you a mark of 20. Okay, right. No questions?
Prof,
So far,
Yeah.
tak ada.
Ronnie or yeah.
Amirul, I have a simple question. So who is actually responsible in drafting all these treaties? So let's say someone draft and then they give it to us, then we see that maybe can we suggest or can we,
Change.
some suggestion? Yes,
All right.
something like that.
Yeah, okay. Right. When it comes to who is the drafter, all right, that person, okay, dengar dulu, nanti saya explain. The drafter of a treaty must be a legislature. It cannot be me and you who is not a legislature, because treaty is law. Therefore, the content of treaty must bear within the character of law. What is law? 3 things. Law is a set of rules. That's why they are the section A, 1, 2, 3, and the rest. It's a set of rules. This rule can only be created by a specific selected group. That is group legislature. Alright, kejap saya tunjukkan siapa. Alright, and the third one is in the body of that set of rule draft by the person who is a selected group. Alright, there must be supplemented with a section, with a sanction. Alright, okay, that is law. So if treaty is law, right, then that treaty can only be drafted. You can write the treaty. That's why we go to the conferences, right? We suggest on the end of the day, the round table. These are a few items, for example, right, that must be paid attention to in the environment, in the immigration, in the refugees, in condoning slavery, human trafficking, whatever you can think of. We meet in a conference. At the end, the conference will have a round table, and they say we are to draft. The round table selected people, and these selected people come up with resolution that they presented to the government. The draft that is done by this group in the round table to call it a resolution proposed to the government, they are not the drafter. They are not the legislature. Who are the legislature? In the parliament, there are these people called executive, administrative, and legislature. Their job is to draft. The AG chambers will look into it. Your resolution will be sent to them. They compile from whatever the group and then put it down. They are specifically legislature. Right? Okay, the appointment of a legislature in a country called Malaysia is done in the constitution. So what is your public contribution? You contribute to the suggestion. You don't create the law. That's why AG, all right, will call lecturers to come to hear, to discuss, and then they will draft it out. And then another lecturer will come in to look into this and that. And AG will look at it again and put the legal words. And then, all right, open for the, there will be a website to test. If you know it, good. If you don't, you missed it. All right. And then it come back to the AG and a lecturer, maybe a professor or maybe a learned professor from overseas will come in and try and draft it again. according to the problem. That's the reason why the wording in the, all right, provision, in the legislation, in the treaty is in such a way. Sometimes we wonder, why is it like that? There's a reason behind, all right? When you, a lawyer or a chambering student or working in a firm, all right, that you draft this and that in the sales and purchase, between one to another, all right, selling and buying a house, there's always the basic sample in your hand, all right, the basic sample too. But here it's not a treaty, it's an agreement between the private person selling and buying, all right. The sample in the original bears with it certain words. I met a lawyer who doesn't like the words to be in that way. According to him, the sales and purchase has to be very clear. But then, does it have the intention to create legal relation if the word is so direct? In the practice today, when we pay deposit, in Malaysia, meaning of deposit is different from the rest of the world. Just to give you an example, that the drafter in the intention of law have a different meaning, in the intention of the practical aspect and the commoner has a different meaning. When we give deposit to buy a house, we expect that that deposit is part of the sales and purchase of the house. That is a common understanding. Some lawyers believe it too. But in the eyes of law, deposit is not part of the sales and purchase. That's why in Malaysia, when you sign an agreement, all right, you actually have already had an oral agreement. You have already given a 10,000, 15,000 to the original owner of the house. If you're not buying it from the, all right, from the contractor, you're buying it from someone who is the old previous. There's a problem there, all right, but this one have been understood. The court have already made a ruling. In Malaysia, all right, deposit is not in the nature of deposit under the contract law, right? Okay, but that is the understanding, because some lawyers will make you sign to say that I have already received 10% of the sales and purchase in my private meeting. When? All right, so the lawyer is not responsible to that, right? That is between you two. Okay, so he will only work on the amount that is in the agreement alone. So you can't turn around later and say the sales and purchase is 900,000, the money I receive is less. Right? Okay, kalau in the true meaning, the sales and purchase, it's not part of the deposit. Deposit should be returned back. That is the meaning in contract. But in actual fact, in the conveyancing aspect, that is the situation in Malaysia. You pay a deposit, you believe it's part of the payment of the purchase price. Okay, can you see? My point is to show to you the drafter intention. It's always the drafter intention that meant to be put in the wording of the treaty. Yeah, who is the one that draft? It's the legislation. When the commoner pay attention to it, you only make the, all right, the cadangan. You only make the proposal that you like it to be. Who would be the best proposal to make the cadangan? It's the wakil.